Okay, we're Artificial Insemination. I'm Kelsey McNeil.
Justin Chang.
Ashley Taylor.
Captain Parnell.
And we have Kelsey McElwain over here working the computer.
Hello. And I'm Haley Newby.
Okay, so we're going to do an overview. We're going to talk about the history and background, the legal issues, contraction of HIV, the homosexual discrimination, donor rights, and procreative injury. Alright, history and background of artificial insemination is a fertility treatment also known as intrauterine insemination. AI is completed by inserting a catheter into a woman's uterus to inject sperm. AI began in 1742 with animals by a Dutch scientist who impregnated a fish. Then 1780, an Italian scientist impregnated a dog. And in the 19th century, the human form of insemination began.
Contraction of HIV through artificial insemination is one of the rarest forms of transmission there is. There's only been 7 documented cases, and all of them were prior to 1985, which is when they invented the test to detect the HIV virus. Usually in these cases they're being tried for negligence or medical malpractice or breach of contract, which is usually implied. HIV-infected semen donations now would be due to negligence because of all the precautionary screening that they can do to the donors. And all this is available to detect HIV and other STDs. And it would be caused by a lack of screening donors and rechecking after a secondary waiting period to make sure that they were clean if it was not detectable in the first test. The plaintiff prior to 1985 always bared the burden of proof. And now that there are tests to detect the virus, the burden of proof rests on the doctor or the hospital's shoulders.
Uh-oh.
Is it still working?
Yeah, I think it's still recording. Yeah, it's still recording. Okay.
Alright.
Oh, okay, this is mine.
Yeah. One case of this is Kobe Ternuzin versus Dr. Korn. And she had participated in Dr. Korn's AI program from 1981 to 1985. And she became infected on her last undergoing of artificial insemination. The physician did not warn her that it was possible to contract HIV, and she was under the assumption that you could only catch it through sexual intercourse. And the jury started off rewarding her $883,800, but the judge actually overturned the ruling because of lack of evidence.
Alright, next question is, should physicians have the right to deny homosexuals assisted reproductive services? The first case and the only case of this is North Coast Women's Care Medical Group versus Guadalupe Benitez. This case was in California. Benitez performed 11 months of treatment at Northwest under Dr. Christine Brody. Northwest was her only provider in her plan that would perform this kind of treatment. One day she revealed to her doctor that she was a lesbian, and Dr. Brody said that she would supervise the treatments but not actually perform the service. But Benitez claims that Brody said she was opposed to it, but she still would do it. When the date came for her procedure, she was told that no one was there who could do the service and was referred to somebody else outside of her provider plan. Bennett sued and said that they violated the Unruh Civil Rights Act. On appeal, they said they'd only denied her due to marital status, not because of her sexual orientation. In 2008, the final judgment was awarded to to Bennett, and Brody paid for Bennett's procedure somewhere else. Okay, these are just a few of the supporting cases. Timothy Curran versus Boy Scouts. He was denied a position due to his sexual orientation, which also violated the Unruh Act. Leach versus Medical Group. She was denied medical care after she wrote and complained to the government, which also violated the Unruh Act. And Washington versus Blampin. This is a minor who was denied a medical treatment due to her race.
My question was, what are the rights of the donors? And in different states, there's different laws. In California, if you go through a physician, even if the insemination is done at home, the sperm donor loses all claim to the child. If the mother is married, the husband of the mother is the legal father. In Florida, if you are found to be the donor under state law, all rights of the child are relinquished, even if the insemination is not done through a physician. Courts will look to any written contracts and determine the parties' intent on the role of the donor. In New York, the contracts regarding sperm donation between a couple and a donor are generally unenforceable, and the court will only look at the best interests of the child and determine their rights. And in Alabama, under supervision of a physician and with the consent of her husband, a wife is inseminated artificially with semen donated by a man, not her husband. The husband is treated in law as if he were the natural father of the child conceived. Also, the donor of the semen provided to a licensed physician for use in artificial insemination of a married woman other than the donor's wife is treated in law as if he were not the natural father of the child conceived.
My question was procreative injury, and currently when things go wrong with the IVF, it's a form of artificial insemination. Patients are unable to win cases against physicians because they're unable to prove physical injury. The law lacks a category of injury fitted to the harm of parents and prospective parents endure when IVF goes wrong. One of the cases I looked at was Stephanie and David Hartner versus the University of Utah Medical Center, and they had triplets, but the doctor had inseminated her with the wrong sperm, so it was not actually her husband's. But because she had not suffered any bodily harms or physical injury that would support an action for negligent infliction of emotional distress, she was not able to win her case. Creed versus United Hospital, the plaintiff's eggs were implanted into the wrong woman, and because the plaintiff attempted to sue for physical injury but lost because she had consented to surgery and the physical and emotional injuries weren't enough to support their malpractice claim. And then Prada versus Medical Offices for Human Reproduction, the plaintiffs filed a medical malpractice action on behalf of them and their daughter. The donor egg that their doctor used was a carrier of cystic fibrosis, but the doctor failed to screen the egg and their daughter was born with cystic fibrosis. The action was denied because the trial court said that the child did not have the fundamental right to be born disease-free. So my recommendation is that IVF patients should be able to file suits under torts, 4 elements, duty, breach, causation, injury, but when it comes to injury, they fall under procreative injury. What this means is that the plaintiffs should not have to prove, or would not have to prove physical injuries along with emotional, but that emotional injuries could be enough to win a case against the defendant.
And likewise, I also targeted procreative injury, but I targeted primarily into adultery and legitimacy. The first case I looked at was in Cook County. If you notice, these two are from the same place, or jurisdiction falls between both of them. In the Hotch versus Hotch, since that happened in 1948, the father was not a willing consenter of the donor's sperm, so the child was deemed illegitimate. And in Dornbos versus Dornbos, the father actually consented to the donor, but the child was still considered illegitimate. And those two directly overruled each other and essentially nullified each other. The next one I looked at was Gursky versus Gursky. The evidence that was presented wasn't founded right because of equitable estoppel, because it was the father and the wife. But it gave you a definition of what an illegitimate child truly is, and it's born out of wedlock or unlawful matrimony. And that is it for our presentation.
I was wondering, she was supposed to be.
I was supposed to be after her, but I don't.
Want to say anything?